This is Mark Sobel. I'm the U.S. Chair of OMFIF. Today, I'm delighted to host three colleagues and world-renowned sovereign debt restructuring experts for a discussion of collective action clauses, the recent Argentinian and Ecuadorian restructurings, and the future of CACs. The timing of today's panel couldn't be better, as according to reports, both the Argentine and Ecuadorian restructurings were approved yesterday. I welcome Lee Goss, Managing Director at the London-based International Capital Markets Association, ICMA, an association of some 600 global financial firms. ICMA, of course, promulgated in 2014 the standard model CACs widely used in international foreign law bond issuances. Lee Buchheit, whose face should appear any second, I hope. His record and achievements are too many to recount, so let me just say he's widely reputed to be the world's foremost sovereign debt restructuring legal expert. He's written a piece with Mitu Gulati entitled The Argentine Collective Action Clause Controversy, which is a great primer for today's discussion. And Brad Setzer of the Council on Foreign Relations. Brad established himself as a leading analyst of sovereign debt restructurings many years ago in a book with Nouriel Roubini entitled Bailouts or Bail-ins. His attention and dedication to the issue has remained steadfast over the years, and he wrote an excellent blog on June 24th in his Follow the Money series on Council of Foreign Relations. All of you should follow that. And this blog was called The State of Argentina's Debt Restructuring, and it relates fundamentally to today's discussion. So let me turn to the three of you for opening discussion, around 8 minutes each, or up to anyway, and then I'll pose some questions, and then we'll turn to the audience. So, and the questions can be sent in via the chat function. So let me start off with Lee Goss. Could you tell us a bit about the evolution of CACs, especially from 2002-3 period to ICMA's 2014 model CACs, including how the ICMA CACs provided for various options, including double and single limb aggregation, and were the ICMA CACs widely used and accepted after their promulgation? So let's start with Lee Goss.
Well, thank you, Mark, and very good to be here today. The starting point with bond contracts is that, unlike shareholder voting, there originally was no majority voting by default. Bond contracts are said to be unitary and originally required the 100% unanimous consent of each and every bondholder to change the bond terms. Majority, or more precisely, supermajority voting by bondholders is made possible through adding collective action clauses into the bond's terms and conditions. And these clauses have indeed evolved over time. The first generation standard CACs were introduced in 2003, and they required a large majority, usually about 75%, of each maturity of an issuer to amend the terms to facilitate a debt restructuring. Importantly, minority bondholders voting against a restructuring are bound by the requisite majority vote of each series of bonds. Later, however, it became apparent that one or more well-resourced hedge funds could obtain a blocking position of more than 25% in a single maturity of a sovereign issuer, leading to holdout creditors possibly frustrating a restructuring and the potential for lengthy litigation. CACs with aggregated voting by some borrowers were introduced with two different votes, often referred to as two-limb voting. For example, the current Euro area model CACs require a vote greater than 50% of each maturity, and also an aggregated vote across all series of greater than 66 2/3 of bondholders. Then in 2013, the lengthy litigation between Argentina and its creditors, and also the Greece 2012 debt crisis, led a group of official and private sector experts to design new generation CACs to address these holdout strategies. So the model CACs published in 2014 by ICMA under both English and New York law contain a menu of alternative voting methods. The first is the older series by series voting. The second is the two-limb aggregated voting. And the last is a new single-limb aggregated voting method that was considered to be the most effective means of countering holdout strategies. The new standard received strong backing from the G20, the IMF, and academic commentators, and their implementation since then has been largely successful, with no adverse pricing or other negative effects observed. Two caveats. As these are commercial contracts between consenting parties, there are two unavoidable shortcomings. They cannot be applied retroactively, so only when new debt replaces old can they be introduced, and they are voluntary. So deviation from any recognized standard is always a possibility. I'll stop there.
Well, thank you. That was quite pithy and wonderful overview. So let me turn to Lee Buchheit. Could you tell us about the Argentine and Ecuadorian restructurings, which limb they use, and some of the creditor-issuer wrangling in the Argentine case? Now, some have also said that the wrangling was caused by inartful legal drafting and in the double limb piece, and others, including creditors, said that it was due to over-aggressive Argentine tactics. And since you are an artiste in legal contract drafting, can you offer your views on that as well?
I will, Mark. Thank you, and good morning, everyone. The Argentine case was a little complicated. Argentina had, broadly speaking, two sets of bonds. They had issued bonds as part of the country's debt restructuring, last debt restructuring in 2005 and 10, that had collective action clauses modeled on the one that Uruguay had used in 2003. It had an aggregated feature. It permitted two-limb voting, to use the terminology that we're using this morning, but at pretty high voting thresholds, 85% for the aggregate vote and 66 2/3 for each individual series. But most of Argentina's bonds in this restructuring had been issued since the spring of 2016 under President Mauricio Macri, and they contained the ICMA model collective action clause that Lee Goss has just summarized for you. Argentina had a tactical decision when it approached this restructuring. It could have attempted to use the single limb uniformly applicable option that the ICMA model clause provides, but it elected not to. For tactical reasons, it felt it could not offer a single instrument to all of its creditors. Remember, it had bondholders, some of whom had bonds maturing in a year and some of whom had bonds maturing in a century. So it felt it couldn't do that. It therefore used the two-limb approach in the ICMA clause. Now, when the ICMA clause was drafted, and everyone on the panel here participated in that exercise, there were a couple of innovations introduced into the two-limb voting, innovations in comparison to the aggregated clause that Uruguay had previewed in 2003. The first is that the voting thresholds were reduced substantially, so that in the ICMA two-limb voting, it requires 2/3 of the aggregate vote rather than 85% in Uruguay, and only 50% of each individual series. Second, the ICMA clause is quite clear in permitting the issuer to decide which series of bonds will be included in a particular aggregation. It need not aggregate the entirety of its universe of bond series. It can, to use the jargon that was used in 2014 in the drafting sessions, sub-aggregate bonds and choose a particular voting pool for purposes of aggregation. But, and this is the important but, the New York ICMA model clause is crystal clear that once the issuer chooses a method of aggregation, whether two limb or single limb and chooses its voting pools, those are fixed for purposes of that offer. It cannot subsequently change the voting pools, for example, without having to redo the offer. Now, that was the feature that caused our Argentine friends some difficulty. And they asked, as part of their offer, for the consent of bondholders to an amendment that would have removed that, what we're now calling all or nothing feature of the ICMA clause. Moreover, they took the position that that amendment was not a so-called reserve matter. It could therefore be approved with only 50% of the bondholders approving it. That was their first innovation. They called it redesignation. They wanted to redesignate, or at least have the option to redesignate the composition of a voting pool by, for example, dropping a series that might not reach that 50% per series approval threshold. The second aspect came to be called somewhat luridly Pac-Man. The Argentine disclosure document filed with the SEC, right up front on the first page, brought to the attention of everyone that it might be possible for an issuer to use a two-limb voting in a first round of restructuring. And if there were series that did not get picked up in the two-limb voting, the issuer could go back at any time, but possibly immediately, with a single limb uniformly applicable offer. And that was thought to be troublesome because the two-limb voting would eliminate naysayers in the original restructuring, but once they had been restructured into an instrument, they could be offered somewhat sweeter terms, and they would outvote in a single limb second restructuring any series that had not participated in the first round. Now, you ask whether this was a product of inartful drafting in 2014 or perfidy on the part of the issuer. I would argue neither. Argentina, as far as redesignation, was quite upfront about it. They did not attempt to pretend that the all or nothing feature of the ICMA 2014 clause was a drafting oversight. They acknowledged it to be just what it is, an all or nothing feature, and they asked for an amendment to remove that feature. So they did that up front. As for Pac-Man, they disclosed this possibility up front. Now, from the standpoint of someone who was on that committee, and my colleagues were also on it, I at least had never considered the possibility of a sequential use of the clause in what we're now calling Pac-Man. I think had we considered it as part of the drafting, we would have done something about it, but we didn't think about it at that point. As for redesignation, the clause is perfectly clear that the voting pools are fixed. The issuer, if a particular series did not reach the 50% voting threshold, had a couple of options. It could redo the offer and relaunch the offer without that pool, or more likely, it would simply go out and give withdrawal rights, announce that a series had failed to reach the 50% threshold, announce what its intentions were with respect to that series and give people withdrawal rights. And at the end of 3 or 5 days, if they didn't withdraw, their tender would be confirmed. So that was the background to the Argentine controversy.
Well, thank you for that. Let me turn to Brad. So Brad, when we all worked on the ICMA clauses, we concentrated on developing single limb aggregation, which we expected to become the focus of sovereign debt restructurings once bonds with the new clauses dominated the market. As we discussed, the clauses were developed in 2014. I haven't seen recent data, but I think bonds with ICMA clauses probably account for more than half the market. Yet double limb was used in Argentina and Ecuador, as we just discussed. And picking up on the wonderful blog that you wrote, can you tell us why? And then can you tell us what your take is on the meaning of this for the future of single limb aggregation? Is it dead? Is its time yet to come? Do we need to do more to make single limb fulfill its promises? And then the two leads can expect that question after Brad. So Brad, the floor is yours.
Well, thank you very much. Look, the ICMA clauses created a lot of flexibility for the debtor because they effectively introduced 4 or 5 different voting approaches, each with their advantages and disadvantages from the point of view of trying to get full participation into an exchange. The most obvious and straightforward way of getting full participation into the exchange was the one we focused on, the single limb, uniformly applicable, one vote up or down succeeds or fails in its entirety. But the provisions that allowed a 1-year bond and a 100-year bond to vote together are pretty restrictive. It has to be, the exact same offer on each dollar of par. And that sort of means that you're giving the 100-year bonds par and a 1-year bonds par the same offer, and the 1-year bond may not, 1-year residual maturity bond may not like that. The ICMA clauses allowed pooling or sub-aggregation, so you could put the 1, 2, 3, 4-year bonds in one pool and the 130, 27-year bonds in another pool, have them vote together, straight up 75% vote within that pool. That was an option that wasn't used in Argentina, but conceptually was there. And then you could go old-fashioned bond by bond, which was also the option not used. The option that was used was the 2-limb bond restructuring, which, on one level has the attractive feature of lowering the per bond threshold, assuming you meet the 67% criteria, to 50%, so the lowest threshold available. But depending on how you did redesignation, it had the unattractive feature of the all or nothing provision. So 50% of any single bond could block. But 2-limb allowed tailored offers for each individual bond series, because you're essentially relying for equity across the bond series on the votes of each individual bond. And so in both Argentina and Ecuador's case, the decision was made to make more tailored offers. Now, there was a sort of particular reason for this relating to the structure of both countries' bonded debt, particularly their bonded debt, which had the 2-limb feature. So, in Argentina's case, 25 billion of the 65 billion was under the old 2005 indenture. It didn't have these multiple voting options, and so the choice was simpler. But for the 40 billion in Macri era bonds that could vote together in the strong aggregation provisions, Argentina was confronted with a choice, and Ecuador faced a similar choice, because there was a concentration of maturities at the very short end, of concentration of big maturities. So of the 40 billion in Macri bonds, roughly 20%, 4 billion bonds were at the very front end, 21s and 22s. And the 21s and 22s, to put it simply, didn't want to get the same offer as the century bond. And therefore, a uniformly applicable offer would likely have produced opposition from close to 20% of your voting pool, which is close to the 25% that blocks. So therefore, you're left with the choice of either taking that risk with a single offer or doing a more tailored offer using one of the other voting provisions that allowed differentiation according to maturity, gave 21s and 22s a better deal. Now, one additional feature of the creditor pool in Argentina's case was that there was an important subset of creditors who more or less held the entire stack of bonds. In the extreme case, they were simply offering their clients the Argentine share of the index, so held all bonds in proportion to their index share. And for them, the distinction between the 21 and the long dated bonds didn't matter so much. On the other hand, if Argentina was going to give a better offer to the 21, they wanted to get the better offer to the 21. But there were a subset of funds that had bought the front end as part of a strategy of buying the cheapest to deliver bonds at the front of the curve cheapest to deliver across all emerging market issuers. And so they had large positions in the 21 and 22, and they wanted a better offer. So hence the decision not to use uniformly applicable. Does this mean that uniformly applicable is not useful or not important? I think not at all. First of all, had this offer failed, and both Argentina and Ecuador were essentially trying to do restructurings without a prolonged period of default. Ecuador had a negotiated standstill. Argentina had a technical default, but there wasn't while there was negotiations. Had the double them offer failed, and had we been in a situation where everyone had accelerated, you're inevitably, after full acceleration, going to use the single limb provisions. And then second, Pac-Man, or using the two features in sequence, was always a threat to the potential holdouts on a double limb vote. So what constrains the front end from demanding too much, given that the double limb voting has this all or nothing feature if you don't redesignate? Well, one risk is that you stay out of the deal, and then guess what? There's a big long end bond, and then you get combined into a voting pool with a new big long end bond and get swept into this new long end bond. I think that's actually a useful constraint on overly aggressive strategies from front end investors. You can push a bit, get a slightly better deal, but if you push too hard, then in some sense it becomes tactically advantageous for the issue to form a coalition with the long end and basically turn your short end bonds into long end bonds, which in a grand scheme of things replicates the results that you would expect from one limb voting. So I don't actually see Pac-Man, at least not if used in the extreme version of turning 25% of support into 100% of support through a whole sequence of votes, which I never thought was possible. I don't see Pac-Man as necessarily abusive or problematic. I think of it as a way of constraining the threat of a holdout series, given the all or nothing nature of two-limb voting. And I see uniformly applicable voting provisions, one-limb voting, as the backstop should a country be unable to reach a more tailored deal.
Mark?
Mark, we can't hear you.
Can you hear me
Somehow
now?
gonna-
Yeah.
Okay. It's the joys of being in the suburbs with lawnmowers and blowers in the background, so I apologize. So let's move from Brad's great answer to the other two leads on that issue. Because single limb was seen as a way of mimicking bankruptcy within a contractual framework. And when we worked on it, it was a useful step forward, especially for those of us who never believed that a sovereign debt restructuring mechanism, bankruptcy type mechanism would be feasible in the US, the UK, or elsewhere. So I was going to ask if the presence of single limb helped create an umbra, so to speak, to advance the Argentine Ecuadorian negotiations. Brad offered his views on that. Does something else, and so I'll put the other question I put to Brad, does something else need to be done to advance the cause of single limb? And then I'll come back to Brad after the two leads to see if he reacts to anything they just said. So which lead would like to go first? Mr. Goss.
Mark, thanks. Yeah, I mean, first of all, I think it's probably a little bit early and probably rash to write off the usefulness of the single limb CACs. Need to let the dust settle a little bit further and study and reflect upon these developments. And these are important developments. And I think one thing we want to assess is whether the relative pros and cons of two-limb versus single-limb CACs have shifted with market developments. The proactive presence of very large institutional asset managers in Argentina and Ecuador, I think, is a very significant shift. We're not seeing the sort of classic holdout strategy. And having these institutions taking the lead in negotiations, but they're also their resources and their ability to block or veto quite easily a two-limb bondholder vote, leading to successive rounds of voting as a factor, as well as whether the uniform applicable condition under single limb deters future sovereigns from using it. I think there's a question whether Argentina interpreted single limb and the uniform applicable condition fully and correctly. I think a number of us have always thought that at the time we adopted the single limb CAC and the uniform applicable condition, we gave quite considerable flexibility, possibly some thought too much to borrowers, in that they could subaggregate and pool to a large extent with certain safeguards. They could, make an offer to, as Brad described, short end, because their interests and outcomes can vary quite a lot if there are long-dated bondholders in the mix. Frankly, the worry at the time was whether we'd given too much scope for borrowers, particularly aggressive borrowers, that they might discriminate or abuse the features. So I think we're going to have to assess that, and also possibly take into account future debt restructurings away from Argentina and Ecuador.
Thank you for that. Mr. Buchheit.
Just let me pick up on something that Lee Gus just said. The assumption when the single limb was being drafted was that giving the issuer complete flexibility to subaggregate would have allowed an Argentina to deal with the diversity of its bondholder groups by subaggregating into pools and offering an instrument, a single instrument to each of those pools. And that's how we thought it was going to be used. Remember, the theory behind the single limb was that if you look at corporate debt workouts, if you look at sovereign debt workouts, as the country approaches the point of marching up the steps of the bankruptcy court for a company or announcing a debt restructuring, the secondary market pricing of the country's bonds normally tends to converge. And so the differences that were present at the time the bonds were issued, the maturities and the interest rate, tend to iron out. And so you normally have a situation where, approaching that final step, the market has homogenized itself in a sense. And therefore, the logic was that an issuer could make a uniformly applicable offer to those people. Why? Because as a mark-to-market matter, they had already converged, and that was the theory of it. Brad is absolutely right, however, when he points out that that works best if the issuer's been in default for quite a long time, because that convergence feature in a sovereign workout will have a long period in which to operate. Where the issuer wants to do a debt restructuring quickly, perhaps even before it has actually defaulted, then you're going to be dealing with a debt stock that will continue to have material differences in secondary market trading prices, and therefore the holders will have materially different expectations as to how they're going to be treated in the workout. Final comment, I don't think we have reached the final stage of evolution of single limb. Remember that the whole point of uniformly applicable offers was to make sure that an issuer could not discriminate against one or a group of series of bonds and in effect use the majority to treat them in a disadvantageous way. And the solution we came up with was, well, look, if everyone is going to be offered the same instrument or the ability to choose from the same menu of instruments, that sort of what we called ganging up was not going to be possible. I'm not sure we have reached the final stage of evolution. I think there is some room for cleverness to work on that problem. I don't have a solution in hand, but I'm looking at my colleagues on this panel and I see a lot of cleverness. So I am hopeful, Mark.
Well, thank you for that. Brad, do you have any reactions to what you heard from the two Lees?
One reaction, which is that I think when sub-aggregation or pooling using a uniformly applicable vote was considered, we didn't give enough weight to how that would compare with the two-limb voting process. And as you narrow down the pool of bonds and you end up pooling, let's say, only two bonds, say the 21 and 22 in Argentina's case, you would have a 75% threshold for those two bonds, which is not terribly attractive if your alternative is the 2/3 two-limb and 50% of each. The place where I think there probably needs to be a little bit more work is actually on the two-limb voting process. And the all or nothingness of it probably is too strong. Having a series where the vote fails, simply drop out is a probably more elegant and easy outcome than having to go back and have a full revote. But I think that's something, and that would get rid of a lot of the issues and concerns around redesignation, which is essentially a workaround to the all or nothing character of two-limb. But there's no question in my mind that if you have a threshold of 50% or a threshold of 75% with sub-aggregation and pooling, there's going to be a pull towards the 50% threshold when there's a large, important bond, and that seems likely to be the case in many future restructurings.
A lot of good food for thought here on possible things to watch out for in the future. So the ICMA CACs were developed after a 1.5-year process. We published them online in a public consultation that Lee Goss managed. The Argentinian language to address redesignation in Pac-Man in the final clauses was quickly put together and behind the scenes. There wasn't a public consultation. So it's great that the restructurings were done, but when I was sitting in the round table, Lee Buchheit educated me that pari passu language had become a total mess over decades because there wasn't a boilerplate and people didn't stick with it. One of the strong suits of the ICMA CACs, in my view, was that they provided a robust, internationally agreed standard endorsed by the G20, the IMF. Has the legal community vetted the recent Argentinian, Ecuadorian redesignation Pac-Man additions to the language? And should it? Does it get the job well done? Lee Goss, would you like to take that one first?
Yes. We, this is doing that. We're just getting started on that. We certainly are reviewing it all. As I touched on earlier, it might be appropriate to first observe if future sovereign debt restructurings affirmatively address redesignation and Pac-Man strategies, or stay silent and stick to the established ICMA standard. We don't know yet whether Argentina and Ecuador are idiosyncratic or a new precedent starting. We had a very unusual situation where we had overlapping sovereign debt restructurings between the two countries and cross-pollination, and a pretty good outcome compared to how it looked midstream, where you had these strategies introduced, or at least proposed, some might say threatened, that caused some concern, but then you quickly attach to each mitigants to safeguard creditors' interests, which is pragmatically a good outcome, maybe an inelegant one. And so I'd be interested just to see whether this is an isolated case or not.
Agreement on that?
Look, I think the redesignation is an inelegant fix to the all or nothing, and the restrictions on redesignation are an inelegant fix to redesignation. So I'm the non-lawyer on this. I could see how lawyers would find this to be an awkward patchwork of compromises. But the end idea that if the issuer wants to essentially get rid of a holdout series in an all or nothing two-limb vote by redesignation, then they give other participating creditors a chance to revote and essentially withdraw their consent. I think that's an effective patch. It looks patchy, but I think it probably works.
Mark, I don't think these fixes in Ecuador and Argentina are going to filter into the drafting of the ICMA clause as it is used in future sovereign bond issuances. Let's take each of them in turn. Redesignation wouldn't have been an issue had Argentina not affirmatively sought an amendment to remove the all or nothing nature of the ICMA two-tier voting. To the extent that any of us have any doubts about whether the market regarded that all or nothing feature as a material protection in the clause, we now know the answer. Argentina walked into a buzzsaw with that proposed amendment, and rightly or wrongly, the market reacted very badly to the idea that that protection was going to be stripped away. I think it was more of a vague fear that there was some mischief afoot in seeking to remove that protection. But let's be clear, the market spoke that all or nothing feature was an important and material term of the ICMA clause. I don't think future sovereigns facing a debt restructuring are going to want to walk into the same buzzsaw. I think they will look at this and say, as Brad just said, if we have a series that doesn't reach the 50% per series threshold, if we have to give people 3 or 5 days with withdrawal rights in an offer that's otherwise successful, we'll do that. And the idea that people would withdraw, you'd have to think of pretty extreme circumstances. What the issuer will have to do, and this is precisely what the all or nothing feature was designed to force the issuer to do, the issuer will have to disclose to the participating creditors how it intends to deal with the series that is being left out of the restructuring, or at least that portion of the restructuring, and that is material to all the other bondholders. Pac-Man is simply, it exists, and Brad has made an eloquent argument as to why it ought to exist. But in future sovereign debt restructurings, I think if the issuer and the majority of its creditors fear Pac-Man, the issuer, I would expect, will voluntarily accept some constraints on the use of sequential offers. The ones that were developed in Ecuador and Argentina seem to work for the creditors caught up in those 2 debt restructurings, but I don't think they're the only way to do it. And so I would expect to see future sovereign issuers restructuring their debt. If the prospect of Pac-Man is going to be a problem, they'll voluntarily accept some restrictions on it so as not to have to go through the drama that Argentina and Ecuador just went through.
Great. Oh, why don't we shift gears a little bit away from ICMA CACs? I just had 2 questions. So there are concerns that the virus may cause a wave of emerging market, frontier market restructurings. Do you feel that the current case-by-case approach can handle the job, or will more aggressive measures be used or needed? And I think Mr. Buchheit worked many years ago on Iraq and a UN Security Council resolution, which was used to temporarily shield Iraq's assets from creditors. That was followed up by US and UK actions. I was just wondering if you had any quick thoughts for us on this.
Why don't I start on that one? There is a concern in certain quarters that if the effect of the pandemic on the world economy is as grisly as the IMF seems to think it might be, that we could be on the cusp of multiple emerging market sovereign debt restructurings of a kind that we haven't seen, frankly, since the 1980s. In the 1980s, 27 countries were restructuring their commercial bank debt pretty much simultaneously, and we haven't seen that ever since then. The issue is how would the market react if you had 15, 20, 25 countries restructuring their debt at the same time using the current case-by-case bespoke method? Would that be an efficient way to do it? The official sector, I think, looks backward at the 1980s and particularly the early 1990s with the Brady Initiative, and says, well, in that era, multiple sovereign debt restructurings followed a very close template, both in the 1980s and in the Brady Plan. Ought we to develop such a template for what might be coming in 2021? The answer, I think, is that it would take the official sector doing something as it did in the Brady Initiative to facilitate those sovereign debt restructurings that would push both the debtor countries and the creditors into following the template. In the Brady era, you recall, the official sector, the IMF and the World Bank, lent the money to the debtor countries doing Brady deals that they used to buy the collateral that secured their new Brady bonds at maturity, and that was the facilitation of those transactions. So that's going to be a question for the official sector. Are they prepared to do something affirmative to assist here? The second part of your question, Mark, is if there are no carrots, or the carrots turn out to be insufficiently large, ought there to be a stick? And that too is being discussed. Should there be some method by which the prospects for recovery by holdout creditors in a sovereign debt workout are diminished, and with the prospect of more limited legal recourse, would they wish to reconsider whether they want to join? You mentioned Iraq. That was a situation in 2003 where the Security Council immunized Iraqi oil assets worldwide in order to both protect Iraq's economy and encourage, let's use that soft word, people to accept an Iraqi debt restructuring. To my knowledge, that's the one and only situation where the Security Council has taken such an extraordinary action. Would they be prepared to do so again? I don't know. It's going to depend on the country and, frankly, the geopolitics involved, because you need all 5 permanent members of the Security Council to consent. So people are looking at potential carrots. They're also looking at potential sticks.
Mark, can I chime in on this question if you don't mind?
Sure, quickly.
So I think there's sort of 2 separate issues. One issue involves the 70-ish countries that are part of the debt service suspension initiative. They kind of collectively have about 60 billion or so in bonds outstanding, best I can tell. It's the World Bank data. It leaves out any issuance in 19. So that would be a restructuring on the scale of Argentina. But it's not going to be a restructuring of 65 countries. The bulk of the exposure is going to be in 10 countries. And some of those 10 countries probably won't want to restructure their bonded debt if that is the condition for getting Paris Club or bilateral debt relief. So I think the universe will shrink. But the key question, frankly, is whether the official sector is going to insist on any restructuring, or whether the official sector will continue to allow countries to take the debt service relief provided by the Paris Club and use it to pay commercial creditors. There's a separate issue, which is, could another large emerging economy or subset of emerging economies get into debt distress and then end up in a sort of a repeat of the 1980s? If you set aside the countries that are already in default that we know about, which are significant, both Lebanon and Venezuela are major issuers, but they issued under the old indentures, and they're not going to be a test for the ICMA clauses. But let's be clear, they're big. So there's some known cases out there. But then if you go beyond that, you have to look at countries that either don't have a lot of aggregate debt, like Turkey, or you have to think countries with a lot of reserves, like Brazil or Mexico, are get into trouble. And I don't think that's all that likely.
Okay. Let me just ask a last question, and then we'll see how much time we have left for audience questions. But it's basically, it's an issue that's always been on my mind. Maybe hopefully I'll phrase it well, but it's about voluntariness and restructuring. So countries want good relations with creditors. They're afraid that if it's a highly adversarial, confrontational restructuring, it will hurt market access for a long time. So they have an incentive if default is at the doorstep to work with the creditors, many of whom have very talented economists who know how to massage spreadsheets. Of course, creditors want the most they can get. So typically an IMF debt sustainability analysis or a program sets an envelope. And I wonder if the voluntariness as it now functions is biased towards resulting in deals that tend toward generosity toward creditors, but may leave the countries vulnerable. And I wonder at times if the IMF needs to be more aggressive in its envelope setting by, for example, aiming for lower debt to GDP ratios or primary surpluses and reducing gross financing need thresholds and the like. Anyway, it's subject's been on my mind for a while. Brad, start with Brad. Do you have a view on this?
Well, I think you're right. I mean, I think the interesting thing is that the IMF's emphasis has shifted towards the gross financing need criteria over time, which has allowed a lot of scope for deals that don't deliver enormous improvements in long-run solvency. They offer some payment reduction in the near term. And I think there is a fair question about whether the IMF should seek to define parameters that force deeper restructurings. The flip side of that is that if you set the parameters more tightly, the result may well be a more like prolonged default while creditors and the issuer are at an impasse. And therefore, you may not have the kind of, you may have a longer period of legal vulnerability. To be clear, Ecuador achieved a rapid restructuring with significant debt service relief, but it's going to come out with a high coupon. The exit coupon is around 7%, and it didn't get any flexibility to handle future oil price shocks. There's no oil contingency in the bonds. That was a trade-off for avoiding a long default right now and getting quick consent. Argentina did get some relief on the long end, reducing the coupon down to 5%, but they now face a wall of maturities in 2025, which is just outside the window set by the kind of the debt sustainability analysis done without a program, which poses risk. Not in neither case did you get the kind of radical transformation of the debt stock that was achieved, say, in the Greek case or in the Argentine case back in 2005. But those, both were much more contentious, difficult processes that weren't played out over a 3-month period. And there is a trade-off.
Do either of the Lees have any views on that?
Well, I think, just generally, voluntariness is both a virtue as well as a drawback of the market-based, good faith, negotiated sovereign debt restructuring process that we have. And I don't think anybody knows if there's at least an achievable, better alternative. But your question is a very, very good one, a very interesting one. Are we doing these restructurings deep enough and painfully enough, or are we taking the easy way out and we're just kicking the can down the road? And I think the key thing is debt sustainability and market access. Now, whether the IMF and their programs could be tougher and have achieve greater debt to GDP reductions, I think it's an interesting question. But as Brad says, it's going to just make it more difficult for the negotiation with creditors. So there's no simple answer on this.
Mark, from my standpoint, you've put your finger on what I've always thought is the overshooting, undershooting problem in sovereign debt workouts. The question, no one knows the future. And debt sustainability analyses, to the extent that they purport to say how much debt a country can be carrying in 20 years is wildly speculative. So the question that debt restructurers will have as they approach a sovereign workout is, ought we to ask for debt relief, very significant debt relief, and run the risk that we overshoot, that it's more than what we turn out to need? Some people would argue that the debt relief Argentina asked for in 2005, with the benefit of hindsight and the fact that we were on the cusp of a commodity boom, was more than what the country needed, and that caused, in part, the large holdout problem that they faced. Or do we ask for a modest amount of debt relief and undershoot? And if we do, the theory goes, and it turns out that more is needed, well, we'll just come back and do it again. Belize has restructured its debt 4 times in the last 13 years. Other countries have done it 2 and 3 times. The problem, I think, is that we have not figured out an appropriate remedy, but either for the undershooting or the overshooting. To the extent that more debt relief is extracted from creditors than it turns out is necessary to return the country to sustainable economic footing, the alternatives that have been looked at involve value recovery instruments, oil warrants, GDP warrants, that sort of thing. That was the theory behind those. There's another group that advocates that the new bonds that are being issued should have an automatic calibration so that the amount and timing of payments are linked in some fashion to the country's future GDP growth. On the undershooting side, the argument is sometimes made, gosh, if we're going to deal with this problem by habitually undershooting, that is, moderating the amount of debt relief that is asked from creditors with the knowledge that the debt restructuring might have to be done again in a couple of years, if that's the way we're going to go, then we should relax these collective action thresholds so that it is easier to get a debt restructuring done without holdouts every time you do it. So maybe even what some people perceive as the generous voting thresholds in the ICMA clause, maybe they should be even lower. That's the argument on that side of it.
Well, thank you for that. I noticed that in the Argentina and Ecuador case, there's a good bit of cash flow relief up front, but and there are some reductions, but it basically pushes the humps out into the future. I've always worried about debt overhangs just impeding countries, but you're absolutely right. Future economic performance is unknowable, and that's really the key to sustainability. So we've had really a fantastic discussion today. There are a lot of questions that have been posed for future work. The future of clauses, will they need to be refined? Do we need to keep our eyes on those? Questions about the whole process. And then beyond the contractual clauses, many of the issues you were just raising, Lee Buchheit, about value recovery instruments and the like and whatnot. So I have a feeling that the world of sovereign debt litigation will be busy for decades and decades to come. Thank you all for joining me today. It's been an honor to have you with us today on OnFifth. Thank you.